welcome to the Australian Institute of International Affairs in Sydney on a beautiful Sydney evening. Our speaker tonight is Professor Simon Butt. Simon is the Professor of Indonesian Law and the Associate Director for Indonesia in the Centre for Asian and Pacific Law at the University of Sydney. He teaches and researches Indonesian law and has published many works, including most recently this one, Judicial Dysfunction in Indonesia. And as a special deal, we're selling copies of it here tonight at a reduced price of $35. So don't listen too hard to what he has to say, because we don't want to steal the magic from the book itself. In accordance with our usual pattern, Simon will speak for half an hour, and then we'll have half an hour for questions and discussions. So, Simon, over to you.
Thank you, Ian. Well, thank you, Ian, and thanks for having me again. This is becoming a habit, and it's a habit I very much appreciate, being the opportunity to indulge. So I was here last time talking about the Indonesian new criminal code, and this time I'm here to talk about some of the themes that emerge from my latest book, which is called, perhaps provocatively, Judicial Dysfunction in Indonesia. So thanks very much for having me along again. I really appreciate it. Now, I was writing this book during COVID lockdowns, and at that stage there was plenty of material which I could write about. So a few years earlier, about 30 Indonesian judges had been convicted for corruption in what seems to have been about a decade-long campaign by the Indonesian Anti-Corruption Commission to stamp down on the so-called judicial mafia. The great thing about some transparency reforms that occurred in Indonesia after the fall of Soeharto was an increase in the publication of judicial decisions in Indonesia, and so the Supreme Court's database had all of these cases involving judges on its website, and so there was plenty of salacious material I could draw from those cases, specifically how corrupt payments are made in Indonesia, how judges kind of cover their tracks, or indeed sometimes don't bother and get caught. Payment in kind, karaoke bars and brothels, that type of kind of seedy enterprise. And the great thing about this database of judicial decisions was that I was able to substantiate all these rumours about judicial corruption that had persisted in Indonesia for many decades. Now, the judges in these cases were both senior and junior, and while they worked across many different courts in Indonesia, including the Supreme Court, the Constitutional Court, administrative courts and others, what struck me was that most of the judges who were convicted of corruption themselves were working in the anti-corruption courts at the time that they were convicted. As Indonesians like to say, you can't sweep the floor with a dirty broom. And at the same time as the Anti-Corruption Commission was moving against all these problematic judges, there wasn't really much that was being done by the Supreme Court or any other body to bring errant judges to heel and to improve judicial standards. So around this time too, and you can read about them in the book, there were many cases that appeared to be miscarriages of justice, kind of represent really significant flaws in the judicial system. And I'm thinking in particular about the case of Jessica Wongso. She was an Australian resident, or she is an Australian resident, who was convicted for murdering her friend by putting cyanide in her iced coffee at an upmarket Jakarta cafe. And her conviction was based on almost no evidence. There was no autopsy even of the victim, so we don't even know for sure whether she was killed or whether she died as a result of cyanide poisoning. As her lawyer tells me, she could well have just died of natural causes. We also had around this time the case of Neil Bantelman, who is a Canadian teacher, was working at the Jakarta International School, and he was also convicted on the basis of almost no evidence. In fact, the only evidence against him were allegations made by children who said he had magic powers. And there were even indications shown on ABC television, of all places, that the children had been coached. And there was another high-profile case that I think made headlines in Australia in addition to these two, the Ahok case, the case involving the blasphemy trial of the former governor of Jakarta. And again, if you want to read the book, you can, but he was convicted on the basis of almost no legally compelling evidence. In fact, he was convicted based on a video that was later proved to be doctored, and the person who doctored it was convicted of doctoring the video at the time. So all of these cases have something murky going on behind them. They're rumoured to have something murky going on behind them. So, for example, the Ahok case, entirely political, and that was designed to prevent him from standing for governor again. And I have it on very good authority that Jokowi actually put it quite starkly to him. He said, withdraw or go to jail, and Ahok decided not to withdraw from the race, and so he went to jail. In the Wongso case, there was rumoured to be a significant business dispute going on between the parties, between the two girls, so Wongso and her alleged victim. I also have it on very good authority that one of the family members of the victim attempted to pay off some of the witnesses in that case, some of the expert witnesses in that case. So this was a case that was broadcast live on TV for many months in Indonesia and caused a lot of controversy. And in the Bantelman case, again, we have something going on behind the scenes. The mother of the alleged victim was trying to extort the school, according to according to rumours. So there's a lot of going on, a lot of misuse of the judicial system, and all the Supreme Court, which will do, and the Supreme Court is responsible for maintaining judicial standards and taking action where necessary. All it did was to focus on the courts meeting their caseload targets, even though there's quite a lot of evidence to suggest that the quality of decisions dropped at the same time. But it's a measurable output, isn't it? And when it did take action against judges, again, this is something I discovered for my research for the book, it held some ethic panel proceedings, and in about a third of the cases it pursued judges for sexual misconduct rather than anything to do with their judicial function. Also rife around the time I was writing the book and appear in the book is allegations of prison sector bribery. I shouldn't say allegations because some of them have been proved in court. One notable example arose from a Tempo magazine report that highlighted that inmates were paying to upgrade their cells with air conditioning and flat screen TVs at a prison called Suka Miskin. And one particularly enterprising inmate had managed to establish and run an unofficial conjugal visit room, which he hired out to other inmates. And this was with the full knowledge of prison officials who took a cut from some of the proceeds of the scheme. So as I said, there was a lot to write about. Now, most of these problems were apparent in the Indonesian Supreme Court and the courts over which it controlled. In other words, every court, perhaps except for the Constitutional Court. And so when I had to pick a picture for my book, I faced a bit of a conundrum. On the one hand, I had what I thought was a pretty good photograph of the Constitutional Court, and that's on the cover now. But it seemed to be the least dysfunctional of all the courts that I'd been looking at. And so I insisted on having the title of the court removed from the top of the building where it normally would appear. So to try and reduce any possible offence that I might cause to some of the judges. I felt a bit guilty about that then, but fast forward to today, and it's clear that the Constitutional Court of Indonesia is as dysfunctional as any other Indonesian court. And so what I want to do tonight, in the time that I have, is discuss why I say these things, these nasty things about the Constitutional Court now. As much as anything else, it's probably fair to say that Prabowo Subianto is already going to be Indonesia's president, its next president, because of judicial impropriety in the Constitutional Court. So, as I just said, Prabowo Subianto will be Indonesia's next president. Now, this is a bit of a problem for the future of democracy in Indonesia, and some will fear it will precipitate a slide back towards the leadership style of Soeharto's new order. Of course, Prabowo is closely associated with that regime. He's Suharto's former son-in-law. He served as Special Forces head during much of the New Order period, allegedly responsible for various human rights abuses, particularly in East Timor and Papua. Now, despite all this, he was elected in a landslide. And there are many reasons why people suggest this may have happened. Some suggest it was partly due to him reshaping his image as a cuddly grandpa type figure, such as in the picture. And people say, or analysts suggest, that he was trying to here appease to the younger voters of Indonesia. Indonesia still was quite a young country proportionally. Many of the voters he's appealing to, I suppose you could say, weren't around during the New Order. They weren't born yet, or were too young to remember what it might have been like to live under a repressive authoritarian regime. But he and his running mate received or obtained about 60% of the vote in presidential polls. And the second place comer, Anies Baswedan, got about a quarter of the vote. The third place getter, Ganjar Pranowo, got around 17%. So he really wiped the floor with his opponents. If he had not got 50%, if he'd not reached 50% of the votes overall, and in 50%, have majority in 50% of Indonesia's provinces, then there would have been a second round election between him and the next ranked pair. But he managed to avoid this, so he'll be taking office in October. So how did this happen? Well, there's lots of potential explanations. I'm going to focus on the legal and constitutional perspective tonight. Before October last year, he was polling pretty well. He was in the lead according to some surveys, but not always. The margin was generally pretty slim. And then in that month, in October last year, he named Gibran as his running mate, Gibran Raka Buming Raka as his running mate. That is, as his vice presidential candidate. He was mayor of Solo at the time, just as his father, the current president, had been, Joko Widodo. So after that, Prabowo enjoyed quite a spike in support. There's various reasons why Gibran was a popular choice for Prabowo, many various explanations that one might put forward. Again, he is Jokowi's son, Joko Widodo's son. Jokowi is very popular still, depending on which polls you read and when you read them, around 70 to 80% popularity rating, so very high. But of course, because of changes made to the constitution after the fall of Soeharto, he can only serve 2 terms, and this is the end of his second term. I suppose having a son in high office is the next best thing to maintaining the presidency. And Jokowi clearly also took advantage of the popularity of Jokowi by choosing Gibran as his running mate. It's also a pretty good move for Jokowi himself, who manages to guarantee continuing influence in Indonesia after he steps down from office. But the problem was that only a few weeks earlier, so at the beginning of October last year, Gibran standing for election was not legally possible. That's because he was not yet 40 years old. And Indonesia's 2017 election law established a 40-year age, or minimum age requirement on candidates. Now, over the years, candidates had challenged the age restriction, had challenged other types of restrictions on candidacy, and in many cases, the court just says, well, the Constitution doesn't impose a restriction, and so the National Parliament can impose whatever restrictions it likes. So the Constitution doesn't impose an age restriction on candidates, so the lawmakers, the DPR, the National Parliament, can do what it likes. Now, from a constitutional law perspective, there's always, in fact, been quite a credible argument upon which the court could remove limits, one that the court has, in fact, accepted in other types of cases. And that argument is that the Constitution sets up a democratic system, and so the people should be allowed to choose who they like. They should not be subject to any restrictions that the National Parliament seeks to impose on their choice of candidates. In other words, we put democracy over whatever other policy imperatives the Parliament might seek to impose. So, for example, we have cases where the court has allowed people who have served jail time for serious offences, including corruption-related offences, the court has basically allowed them to stand by removing statutory limitations or restrictions on former convicts standing for office, on the basis that if on the basis that democracy demands that people be able to make an informed choice, as long as the candidates are open about the fact that they've served jail time for various offences, then that is it's up to voters to decide. Now, this is where it gets, I think, quite interesting. So, we have a situation where Gibran, Jokowi's son, can't stand for the presidential election because he's 40 years, or younger than 40 years. In comes the Constitutional Court. Now, I said the court had heard a number of cases about this restriction and other types of restrictions before, but on Monday the 16th of October last year, the court convened to read out a number of decisions. It tends to have a decision reading day every now and then, where it kind of sits and reads out the judgments in front of them. Now, on the morning of that day, the court read out 3 decisions about this age limit that it had made. And in all 3 of those cases, the court decided by a majority of 6 judges to 2 that the age limit didn't violate the Constitution. And there are a couple of judges that dissented. I won't go into their the reasons for their dissent right now. But then later on the very same day, so after a lunch break, the court came back and read out a further decision, also about the age limit. And on that day, the court in that afternoon decision, the court reached the precise opposite conclusion. It said it's possible for candidates to stand for election, even if they are under 40, provided they have experience in regional office, which of course Gibran did as mayor. So we had on the same day, just to restate, we had on the same day the court handing down 3 decisions in the morning, and then in the afternoon the court contradicting those 3 decisions that it gave in the morning. one of the questions that arose was the role of the Chief Justice in all of this. Now, Anwar Usman, who was the Chief Justice, he didn't participate in deciding in the cases that were read out in the morning, but he did participate in the decision that was reached in the afternoon. He did put his vote in, did debate the decision with judges kind of outside of court. So, the controversial aspect of this is that Anwar Usman, the Chief Justice, is also Jokowi's brother-in-law and the uncle of Gibran. And the assumption is that he somehow managed to swing the court into changing its view. Now, the details are a bit murky, but everyone, or all the judges, thought that Usman, and this is revealed in interviews, and some judges mentioned this in the decision itself, they thought that Usman sat out in relation to discussions about those first three decisions because he had a conflict of interest, because Gibran was his nephew, and if the age limit was restricted or removed, then he would be allowed to stand for election. So he had a conflict of interest and therefore sat out. That's what the court, that's what the other judges thought. But then when he did turn up for the meeting that kind of resulted in the decision that did allow Gibran to stand, he said, "No, I had never had a conflict of interest. I was just sick that day." But he did manage to somehow convince the other three judges to change their minds, and so everyone's kind of wondering what he did to do that. There's rumours that the judges were offered money to change their views. A figure of 10 billion rupiah is bandied around. But regardless of what went on behind the scenes, this decision paved the way for the announcement of the nomination of Gibran to run with Prabowo, and as I said, probably kind of led to a spike in support for Prabowo before the elections. There were lots of protests. Civil society was up in arms, but they got very little traction. This is a problem that we have in today's Indonesia, where civil society seems to be losing its voice a bit. Someone did, however, manage to get the name of the Mahkamah Konstitusi doctored on Google Maps. So if you remember back to the first slide, I was talking about how I removed the writing, the name of the court from the picture. Well, someone managed to substitute Mahkamah Konstitusi so that it read Mahkamah Keluarga whenever you went to find the court on Google Maps, and that's the family court. Pointing to the fact that there was a bit of family support going on, Usman for his nephew in particular. So what happened then? Oh, sorry, there's just a little picture of me meeting the Chief Justice and his wife before the scandal broke. So we have a real problem in the court. We have an inconsistent decision handed down on the same day. We have allegations of nepotism in the court, allegations of corruption in the court. And so what does the court do to try and fix the situation? Well, it has what it calls an ethics council hearing. So we have here a picture of the three people who were involved in this ethics hearing. And one of the proceedings in the hearings involved allegations that Anwar Usman, the Chief Justice, should have recused himself. Now, this panel actually stripped him of his Chief Justiceship and made him, demoted him to become an ordinary judge. This gentleman here is an academic And he, in fact, dissented from the view of the other two judges. He would have had him removed from the court altogether, which I think is probably a more appropriate outcome. But just to show you how problematic the judiciary is in Indonesia, various processes. This member of the panel that was convened to consider whether Usman should be removed or demoted was also on the panel of judges involved in making the controversial decision. And this judge, well, former judge, Jimli Asidiki, one of Indonesia's best known constitutional law experts, founding member of the Constitutional Court, is very well respected, an excellent lawyer, a great judge, but he also was head of Prabowo's legal team during the election campaign. So we have an allegation made here that a judge should have recused himself from proceedings involving the interests of his nephew, being presided over by a judge who probably or former judge who probably should have recused himself for being a member of Prabowo's legal team in the first place. So, you know, contradiction over contradiction. Now, there was one judge who basically argued that this, in his decisions, that the restriction on age should be removed. And this judge, by the name of Guntur Hamzah, is also extremely controversial in Indonesia. So in that first batch of 3 decisions, he says we should remove the age limit, but he's really the only judge at that time that makes that argument in his decision. Then later on in the afternoon, many of the judges have switched sides and have essentially adopted his decision. So he provided a bit of a template for the switching judges for the afternoon session. Now, his appointment to the court is also highly questionable. And to tell this story, I need to go back to September 2020, when the National Parliament decided to increase the tenure of judges of the Constitutional Court. So previously, judges would serve for 5-year terms and they could be reappointed for an additional 5 years. The legislature, the National Parliament, decided that instead they would introduce a system whereby judges would be appointed for 15 years. And they could retire at age 70. Now, the Indonesian media thought this was a gift for Constitutional Court judges, designed to ensure that the judges were loyal to the government if a case came up involving government interests, as most Constitutional Court cases do. But really, in many legal systems, having a guarantee of judicial tenure is in fact an essential aspect of judicial independence and the rule of law. In Indonesia, it was not viewed that way. Anyway, so the Parliament issues this law, gives the Constitutional Court judges longer in office, and someone challenges some of these extensions in the Constitutional Court itself, and the Constitutional Court doesn't shy away from cases involving its own procedures and interests. And essentially what the Constitutional Court did was it said, well, yes, that's right, 15 years, but there are some judges who have already been serving for a few years, so just to make it very clear, we'll, in our decision, to specify when we think their terms end, that is 15 years from when they started. And what they did was they wrote a letter informing the institutions of government about these changes. Now, in the court, there's 9 judges. 3 judges are appointed by the President, 3 by the Supreme Court, and 3 by the National Parliament. So when the court wrote this letter explaining the decision to the National Parliament, the National Parliament took this as an invitation to reassess whether it wanted the judges it had initially nominated to the court to stay on the court. And it decided it would remove one of the judges. And it gave no kind of attempt to do this legally. the one of the members of Parliament essentially said, well, if you're a corporation and the director doesn't follow your policy, if you're a shareholder and the director doesn't follow your policy, then of course you're going to remove them, aren't you? Essentially, there were decisions that this judge had made that the Parliament didn't like, and so they just got rid of him. And this is a real problem because presumably other nominating institutions could do the same for the judges that they decide they don't like anymore either. So, the long and short of the story, as it's kind of playing out, or has played out in Indonesia, is that the judge that the National Parliament didn't like was replaced by this gentleman here, Guntur Hamzah. Now, he was later found guilty again by an ethics body established by the Constitutional Court of doctoring a judicial decision. I think it's one of the first decisions he was ever involved in producing. And I don't have time to talk about precisely what that decision related to, but I can if you want to pursue it in questions. So he's a problematic choice, widely seen as a kind of person to do the government's bidding in the court. Now, of course, none of this bodes very well for the future of the Constitutional Court in Indonesia. The Constitutional Court's role in ensuring electoral democracy in Indonesia is all but shot. Now, in the past few elections, it's played a crucial role in helping resolve disputes about the results, and it's played a crucial role also in adjudicating allegations of electoral impropriety. It hasn't been perfect, but it's kept the peace at least. Now, Prabowo's electoral opponents are challenging some of the results in the court, but I don't know what the point of this is, because the court has already shown that it's pro-Prabowo by allowing Gibran to stand. I suppose the real danger is we're not quite sure what Prabowo will do next. In previous campaigns, this is his third time, I think, trying to run for president, finally successful, he told voters, vote for me, but only the once. The implication was that once in office, he would dismantle Indonesia's democratic electoral system, or at least rig things heavily in his favour. He also said once that he would try and roll back the amendments made in 1999, 2000, 2001, 2002 that propelled Indonesia towards democracy. One of these amendments established the Constitutional Court itself. So it may be by signing off on this decision allowing Gibran to stand, the court has signed its own death warrant. Now I finish here with a picture that was produced by my friend and colleague Professor Tim Lindsay from the University of Melbourne. Not only is he an excellent legal scholar and political analyst and everything else, he's also, quite frustratingly, an excellent artist. Now I wanted that for the cover of the book, but the publishers didn't like it. So that's a bit of an update really on what's been happening since I finished writing the book. There's plenty to read in there if you're interested for some more juicy details, but I'll have to leave those stories for another day. Thank you.
Thank you, Simon. We now have half an hour for questions. Please wait until our colleague armed with the microphone reaches you, and then stand up and ask your question. We'll start with you.
Thank you, Professor Butt, for your excellent presentation. Anjali Bakon from the Australia-Indonesia Youth Association. So my question is about a legal case that took place last year. Undoubtedly you heard, and many Australians heard, about the 25-year-old Australian surfer Body Money Risby Jones, who went on a drunken rampage in Aceh last year. What really struck me about the case was, well, not only the egregious nature of his crimes. I mean, one of the fishermen got like 50 stitches, but also the fact that he was able to pay a financial settlement of about 25,000 Australian dollars and was able to return home. So I guess my question is, firstly, how common is the use of financial settlement to settle criminal legal matters in Indonesia's legal system? And secondly, what are some of the major challenges that Australians who are caught up in Indonesia's criminal legal system have to be, wary about, I guess?
Yeah, good
Thank
questions.
you.
Thank you. Can I answer straight away? Yeah. So, yes, this is an interesting question. So to what extent can someone buy themselves out of criminal punishment in Indonesia? Well, in the new criminal code that I talked about last year when I was here, I don't know if I covered this aspect, there is in fact provision for criminal settlement by negotiation. So in the circumstances of this case, you have a drunken rampage resulting in an assault and injury. So the victim can gain compensation, and therefore the perpetrator can avoid jail time. The problem is that, at least on my recollection of the code and various laws that may have applied, you actually have to pay a fine to the state as well, and you have to pay the maximum fine in order to kind of enliven the provisions that allow for a criminal settlement like this. And I'm not sure whether that happened in this case. So I don't want to speculate too much because I don't know. I wasn't involved in that case, but I presume there would have been some payments made at the same time to allow him to leave, in addition to the settlement. So whether that serves the purposes of the criminal justice system or not, I'll leave to you. But there's certainly, well, if it's like many other cases I've heard about in Indonesia, I wouldn't be surprised if there was something going on. And this raises another question, particularly for people who want to go into doing business in Indonesia, perhaps like your good self and your friends at AYA. The criminalisation of the Indonesian civil dispute resolution process. So the number of cases that I hear about involving people who get into business disputes in Indonesia, particularly foreigners who get into trouble with Indonesian parties, who then find themselves woken up in the middle of the night, knock on the door from the police after being reported for a crime that they didn't commit by their business rival. So we've got a business dispute that's turned into a criminal matter, an unrelated criminal matter by a kind of vindictive business partner who wants to use connections with the police and others in order to kind of negotiate out of a civil dispute. There are quite a number of cases that I've heard of where this happens quite a lot, and it's a real problem. It's one of the reasons, I think, and people will correct me if I'm wrong, one of the reasons why I think Australians underinvest in Indonesia. They hear these horror stories. But at the same time, there are a lot of companies that brave the risks and do it anyway. So it's always going to be a balance between taking the risk and keeping everyone happy, which can be difficult in Indonesia. You want to avoid getting your friends offside. It's interesting though, sorry, just one more comment. So the Bantelman case I mentioned, that Canadian teacher, he somehow managed to get parole and be shipped off to Canada without anyone knowing. Now, I'm not saying that's a bad result for him, given what, and it's an inappropriate result given what he had to go through in Indonesia, which is a trial for something he almost certainly didn't do. But it also underlines the fact that you can get things done on the sly in Indonesia. So somehow, even though he's been formally convicted, he manages to not undergo the parole process, say, for example, that Schapelle Corby underwent. Remember that she went into a hotel in Bali for a while. She wasn't allowed to leave because prison officials needed to check on her to make sure she was meeting the conditions of parole. It was almost as if there was an acknowledgement by officials that Bantelman didn't do what he'd been accused of doing because they allowed him just to leave rather than make him go through this process.
But he'd done 5 years in jail.
He'd done some time in jail already, that's right. But his sentence certainly hadn't finished. So, yeah, there's a lot of interesting manoeuvres going on there too.
Next question. Here under.
G'day, Pat Hanna from the Australian Indonesian Association. Very good talk, appreciated that.
Thank you.
There's quite a few things I'd like to discuss, but the first one you kicked off with 30 judges found guilty of misappropriation. That's out of about, I believe, 7,500 judges.
Yes, that's
right.
right.
Yeah. And I think Australia, we've got about 600 judges, and I think we'd have about 30 that should be in jail as well. So I think it's quite a small amount when you look at it. I know of a very good lawyer in Jakarta. She's as straight as the day is long, and she will swear that the law in Indonesia works if you know the law. And obviously, you have to understand the culture as well to know the law, because it can be interpreted quite differently from the way we interpret it, because we're a very different culture again. And the cases where Australians have been got into trouble because of the police, coming up with false evidence, etc. She's defended quite a few of them, and in fact, in each case, she's always managed to get them out of trouble, and they are allowed to stay in the country because she, in fact, read the riot act to the police who came up with all these allegations. And that's the way things seem to happen in Indonesia. If you know what's causing the problem, illegal problem,
Point, yeah.
yeah, and that's why she's very, very successful. So I would think that there are a lot of cases, that we hear about, and I think that what we don't hear is the whole story.
Yes, that's true.
And as she says, the law does work and she has been to court. That's another thing she says. A lot of lawyers that I know of, especially expats that live there, have never had to go to court to defend somebody. When you have to do that, you really need to be an Indonesian lawyer, because you need to interpret those laws Indonesian style. That's my point.
Yes,
Yeah.
yes, thank you, that's interesting. So, if I just respond, so no one's suggesting that all Indonesian courts and judges are corrupt. Maybe I did suggest that actually, so maybe I should wind that back. And the book is provocatively titled. So there are, and everyone who writes about Indonesian law and courts and corruption says there are judges that are clean. There are lawyers that are clean. But I just can't, there are lawyers that are, I'm thinking of people like Mulia Lubis, he represented the Scott Rush and Sukumaran and Chan, Sukumaran and Chan, I should say, who are just, as you say, straight as a die. Their integrity is very high, etc. But I sometimes wonder how they do, important big commercial transactions and things, particularly with government, because I think it's pretty hard to get a contract with the government without being engaging in that type of thing. Sure, there may be exceptions. People who have particularly good relationships with individuals might be able to avoid it, but it'd be pretty difficult, I think. I also want the name of your lawyer. She sounds really interesting. But the other point is, you said that 30 judges out of 7,500 or 8,500 judges. There are also lots of court employees who've been convicted as well. I didn't talk about them. Is that the tip of the iceberg, or are they outliers? So it's hard to tell. Most people I know think that it's the tip of the iceberg, but you can't prove it. One of the difficult things about corruption is proving it. People try and cover their tracks. It's not easy to find people, find the evidence. That's what made these cases so interesting, because this evidence was put in court and everyone can see what the judges were alleged to have done or found guilty of doing. But yes, I acknowledge there are problems with estimating the extent of corruption. But Another point that I would have made had I had more time is that the problem's been acknowledged by Chief Justices of the Supreme Court, of the Constitutional Court. Many other judges have kind of said, yes, it's a really big problem. And the president, so the former president, SBY, even set up a judicial mafia task force to look into allegations of kind of the judicial mafia, so police, prosecutors, judges, all in cahoots, at least in criminal cases, and confirmed many of the worst fears. So for the president to establish a team that then kind of made these findings was pretty damning.
The next question was from Matt.
Hi, hello. Indonesia today is a unitary state. So my question for you is there a part of Indonesian jurisprudence which recognises Indonesia should be a federal state in order to dilute the both judicial and political power based in Jakarta? And I say that because, of course, there was a movement in the late 1950s, the permissive movement, which advocated for a more regional architecture of Indonesia. And even as recently as the conflict in Ambon, there was a movement for a more regional power structure in Indonesia. Thank you.
Thank you. Yes, the F word in Indonesia, federalism, often almost always kind of considered with disdain because of the historical association with the Dutch trying to establish a federal state, or at least supporting one. Indonesia, as you say, is a unitary state. I think it's probably fair to say that after the fall of Soeharto, we had as close to a federation as you could probably get with regional autonomy, because you had a significant devolution of power to the regions. But it wasn't a federal system because the government, the central government, could essentially override the local governments at will. Now, there's a few qualifications that I'd make about that, but the general trend has been probably to wind back some of these reforms and bring more power to the centre. And with the election of Prabowo, who knows what will happen next? We may even see a more centralised system.
Next question. We've got two here, so
Jeremy Webb in the Queensland branch. To what extent is payment of judges an issue? I mean, is there an attempt to give them sufficient resources to not to be bribed, or I suppose that problem may slink down to the other people in the judicial system, but for judges, is their payment adequate?
Yes, thanks, Jeremy. It's one of the first things that reformists say we should do to reduce judicial corruption, not just in Indonesia but in many other countries of the world as well. So in Singapore you have very, very, very well paid judges, $1 million type well paid, and they're apparently virtually incorruptible. In Indonesia we have seen the judges' salaries increase. So there were, I think, at least 2 increases, like market increases beyond what normal public servants would expect after the fall of Soeharto. I don't think that's worked. Most people would say, I think that corruption's got worse since the pay rises have occurred. Might not be because of the pay rises, probably no association between the two things. But I've always suspected that the higher the judges are paid, probably the higher the bribe needs to be for them to. But that's me being a bit facetious, but I could see how it might work that way. So I don't know if increasing salaries of itself will do very much, but if you tied it to, say, performance indicators, quite what those performance indicators would be is another question. Then perhaps it might have more traction. But I think it's been pretty much discredited in the law and development literature as a way of reducing corruption.
Thanks, Mel. Glenn Robinson. I've been working in Indonesia on and off for the last 35 years. and I've worked with companies who are investing there. And probably, certainly several hundred companies I've worked with, and I've never paid a bribe, and nor have the guys with whom I worked paid a bribe. Now, I've had to walk away from some projects because people were expecting to be paid, but I think it's an expectation that's in the world that we make payments. I believe now that while 30 years ago it was pretty bad, now it's bad but not all as bad as it used to be. It's certainly moving down. The other thing I compare it with is what goes on in here in Australia. Yeah, the cops here just shoot somebody.
Yeah, no, thanks. I mean, those are great points. But I think maybe your relationships fall into that category of, where if you've got a good, you've got a kind of a good partner that you trust and you trust each other, etc. Then perhaps you don't need to.
Narrow. They don't get that outside the law.
Yeah. Well, I haven't done business in Indonesia like you, but from what I hear and read about, it's different people have different experiences, don't they?
Sure. I think I might want to make the point that it's not all one way.
Yeah. Oh, you mean so it's not just extortion, but it's Australian investors, seeking to smooth the way a bit.
I reckon once I retire, or get retired, I'm going to go up to the airport at Jakarta and stand there for all the Australians that come through and say, "Here I am, pay me."
And that's right. You'll be funded. Your retirement will be funded because they'll just go, "Yeah, okay, I'm supposed to do that." Richard.
I imagine, Richard Brunowski, you would probably do very well as a private consultant for Australian businesses wanting to operate in Indonesia. Can you tell us whether you have any background, experience, knowledge of how the Japanese or the Koreans or the Chinese operate in Indonesia? Is there some special cabal of Oriental knowledge that we don't possess? I mean, Paul Keating has often complained about the fact that Australia, the biggest Muslim neighbour, our closest neighbour, kiss the ground when you get there. We should do more in Indonesia. Meanwhile, other Asian countries are doing very well, thank you very much. What sort of insight do you have, if any, about how these countries, particularly the Japanese, operate very successly in Indonesia?
Yeah. No, I don't have any insights onto that question, I'm sorry. But but you're right. I mean, Australia does pretty badly in Indonesia compared to other countries. But surprisingly, England also does quite well.
Everybody else does well.
Yeah.
But not as well as the Japanese, though.
That's right. Japanese is huge. Yeah, and Chinese too.
I have some experience with that because I've worked with the Japanese in Indonesia. They do spend a lot of money on projects. They have a lot of money, so they'll go in to do things like research into geothermal generation, things like that. And they spend a lot of money, so they get that respect from the Indonesians, and that opens a lot of doors. There's no doubt about it. They do get frustrated by the corruption as well. They don't really agree with it, and they don't like to play that game at all. So they do their best, as I said, to do the right thing and invest, as do a lot of the Canadians are the same. They throw a lot of money and help develop projects and things like that, which is what Jokowi was always asking for. Come and spend some money, help me develop my country. I need infrastructure. And that's what he basically did for 10 years, which was good. I just wanted to finish off on the last point, because you talked about Jokowi's son being appointed, and I think it was interesting from my friends in Indonesia saying that, and I asked, why did he appoint Prabowo as the Minister for Defence as soon as he got in? And the answer was, you bring your friends close, but you bring your enemies even closer. And that's what he did. And he then had 10 years to work on this guy to get him to a point where he was a better statesman than he would have been had he gone in on his own. And now he's put in a reassurance, a little bit of insurance in there to put his son in there to keep an eye on this guy. So I think that you'll find that Prabowo won't be the Prabowo of 20 years ago. He'll be a different type of person.
I hope not.
Yeah, we all do.
Yeah,
but I think the Indonesians think that as well. It's
Yeah.
interesting, yeah.
Yeah.
It's a fascinating election result, and we're going to have an event on that and on the
Excellent.
prospects a little bit later in the year. We've got time for a couple more questions, but if I can just say, you've been coming and going to Indonesia since you were a very young man. Getting back to the specifics of the legal profession, and particularly the corruption of courts, is it getting better or worse?
It's a good question, and no one really knows. Again, we've got this data now of 30 convictions, etc. And then we think, well, that was kind of 10 years ago that those cases ended. And no one really thinks that anything's changed much since then. And then you have these kinds of scandals, the Constitutional Court scandals coming along as well. Again, allegations of corruption to switch sides in decisions, these types of things. So my perception is no, it hasn't got any better. But I base that not on any empirical data. It's just the impression I get. No one seems to be positive about any judicial reform, really.
Thank you. Right, well, as I say, time for two more questions. One here.
Hi, my name's Joe. I'm probably the newest member here. Thank you. It's nice to be here. Just a couple of things that occurred to me before the questions, but then they've been partially covered in the questions. The first one is in relation to the Anti-Corruption Commission, which gained global prominence as one of the most straight and narrow, decent anti-corruption commissions in the world, with the least amount of political corruption involved. Has that been dismantled now? I understand that might have been what was going to happen. And the other part of it is in relation to corruption. My Indonesian guide and driver calls it from the gardener to the president. And the other part about the other side of that coin is, of course, that there's no such security in Indonesia. And I've always been overwhelmed with wonder at how every single person has a role, and each person does something, gets a little bit of money for it, and this is sort of like the fluid that makes the whole thing hang together. The other thing I wanted to talk about and ask you is about the less veneer that Indonesia has on many things, and how we can see this as a very open sort of give the police officer 50,000 rupiah and drive on, and is in fact the case that it's less obvious here and veneered over with more layers of veneer. And does Indonesia teach us something about humanity and all of our moral or political selves?
Well, that's getting very existential for Tuesday night. But look, the Anti-Corruption Commission is in trouble. So after all the reforms of the post-Soeharto era, I mean, I guess I come at it from a legal perspective, but we had the Constitutional Court, it kind of shone for a bit, and now it seems to be in tatters. The Anti-Corruption Commission also, as you say, shone for a bit, for quite some time actually. Then the National Parliament passed some laws to weaken it, and I won't go into the details of that, but the main problem, I mean, that the most recent head of the commission is now being charged with corruption himself. That's never a good look. And a number of employees from the Anti-Corruption Commission have been being investigated by the Commission for, I think, taking bribes or allegedly taking bribes from those detained in Anti-Corruption Commission detention centres. So this is not good for the Anti-Corruption Commission, obviously. The institution was weakened by these laws, but also one of the problems was that the heads changed. So I've said the commissioner, the head chief commissioner, was found was being investigated. But there are 5 KPK or Anti-Corruption Commission investigators, and the quality you could see at its peak. The quality of the commissioners was excellent. They were really good reformist, smart people, and then they just got replaced with people who weren't interested in doing the job, particularly the head. And so we've just seen this slow death of the commission. So some would say that with the kind of the decline of these two institutions, Reformasi, if it wasn't already dead, is certainly almost dead now, which is really depressing. Now, I've always thought of that kind of petty bribery in Indonesia, where you're paying a policeman to let you off when you've probably done the wrong thing. But also when you're, going to a government department and you need to pay unofficial money to get things done that you might otherwise expect, as almost fee for service. So, police, you hear the rumours, well, they don't get a budget for their motorcycles, or their, keep their clothes, in rappy condition. You also hear stories about all those motorcades driving down, big streets in Jakarta. I mean, anyone can buy these, or can pay to have these motorcades. Apparently, it's like $500 or something like that. And so the police take the money, but they use it to maintain their motorbikes. So not all the illegitimate money is going into the pockets of the people that take it. Public servants might get paid a very, very low base rate and make up the shortfall by taking these types of payments. Again, I've just given the example of police, but the same goes for prosecutors and judges, no doubt. Visas, yeah, that's right. So it's not a kind of a zero-sum game. It's not obvious that all the money's going into various pockets. And as you said, some of it gets distributed around. Or you suggested some of it gets distributed around to various people who might otherwise be quite lowly paid.
Great, thank you. Let me just mention that our next event, next Tuesday, will also be all about a book. It's a book called The Politics of Climate Change in Oceania, and one of the 3 editors of this collection of writings, Wes Morgan, will be here to talk about the book, and as we're doing tonight, to make copies available for those who've got enough money one way or the other. But to round off our event tonight, I'd like to invite one of our interns to move a formal word of thanks.
We have had a very distinguished Australian as our speaker this evening, Professor Simon Butt's extensive history as a consultant on the Indonesian legal system, as well as his experience as Associate Director for the University of Sydney's Centre for Asian and Pacific Law, has cemented his status as a leading authority on the Indonesian legal system. His discussion of judicial dysfunction within the country has given us a window into the inner workings of one of the fastest growing middle powers in the entire region. This talk has generated interesting questions from the audience, and Professor Butt has answered equally interesting answers. He made a particular telling point that most of the judges convicted for corruption were actually working on anti-corruption courts themselves. He has given me insight into how Australia should understand Indonesia's law as our middle powers move to cooperate amidst increasing regional insecurity. I move that we express our thanks to Professor Butt for his address with a round of applause.